Swayam Prabha. Digital India. Educated India.
So, moving on to understanding the definition of state under Article 12 of the Constitution through some judiciary and landmark cases, one would take into consideration at least three very important cases. First and the foremost is the Rajasthan State Electricity versus Mohanlal. It's a 1967 Supreme Court judgment. The second is the Ajay Hasia versus Khalid Mujib. It's a 1980 judgment. And the third is the R.D. Shetty versus the Airport Authority of India, which is the most landmark judgment given by Justice B.N. Bhagwati in understanding Article 12. Now we know, friends, Article 12 defines state, which has certain four parameters. First, of course, the government of India and the Parliament of India is the state. The legislature of each state is also state. All local and other authorities within the territory of India. So once you are an authority of the state, you are also a state. And finally, you have other authorities. Now, these other authorities are sometimes quite interesting and challenging because local authorities, I have already told you, are the municipalities, it is the panchayats, it is the boards and the trusts. These are local authorities because they do local administration, they do local government, and these are also doing what we call as local public administration. Because the country is so huge, the demography of the country, the topography, the kind of landscape that we have, challenges that we have, the citizens' welfare interests that we have, I think the authorities have to be divided. So in terms of centralization versus decentralization of governance, I think this becomes a very critical factor. Now, understanding other authorities in the Constitution thereby shows a certain degree of challenge because you either include these under Article 12 or you exclude them. And to include them, what should be the test? To exclude them, what should be the test? Because finally, friends, when you are other authority, please note the basic distinction is whether you are a state authority or whether you are a private authority. If you're a state authority, you're covered under Article 12. But if you're a private authority, because see, the term authority is quite interesting. An authority is someone who is in a position to determine something about you. Right? A father may have authority over his family. If you go to a hotel, they have certain authority to lay down the rules of regulation of admission. Sometimes they say the right of admission is reserved. So this is the kind of authority because it is your property. You have the authority to determine the rules and regulations of the same. Hence, who are these authorities who are accountable under the Constitution? Who are these authorities who can be held responsible for the protection of the rights of the citizen? And who are these authorities that will be exercising public administration? I think this is the critical and the vital question that arises when we try and understand authorities under Article 12. Now, interestingly, friends, please know, once you are an authority of the state, or once you are state under Article 12, even if you're not the authority, please note, very often than not, the employees seem to be working for the state. The employees seem to be so-called government employees. The government is kind of paying the salary of the public servants. There is this kind of a degree of so-called ownership in creation of that authority by the state, or it could be a degree of control that the state exercises as well. So, control and ownership of the entity will determine whether it is to be included within the definition of state or not. And hence, the kind of the constitution that we have created is to say that, of course, we make a distinction between public authority and private authority. Public authorities have a different set of accountability in the constitution. Private authorities have also a set of accountability, but they are of a different scale and mandate. And hence, uh, either we say that you are a sovereign body. Now, a sovereign body is what? A sovereign body is the body of the government itself, right? State or center. We say government is sovereign. This is something that you say is sovereign because they are supreme. They are sovereign because they perform core governmental functions which no one else can perform, and they are sovereign because they, reflect the interest of the citizens at the government. So, when any entity is a direct reflection of government and governance, they are considered to be sovereign bodies. But interestingly, today you talk about the welfare state. Now, what is a welfare state? A welfare state is not only doing governance, or government is not only focusing on governance. Today, the government itself is providing a lot of civic amenities. It can provide a lot of facilities. It can actually get into production of goods and services. It can extract mineral resources. It can probably, for example, supply water. Water is accessing water in the river, building dams, supplying it through canals, and trying to give it to citizens. Now, the services of water is not necessarily a core government service of essential sovereignty. It could be a kind of a welfare function. Now, when you have a water board, or for example, take the electricity board, the Rajasthan State Electricity was Mohanlal. Now, electricity boards have the power of promoting, coordinating the development of electricity, including generation, supply, distribution, and transmission. And hence, the state has invested quite a bit in the transmission lines, in the generation lines, and so on. Though, despite the fact that today we are talking of an era of privatization, 1967 there was no privatization. Today there can be privatization, and hence a private power company is not going to be deterministic. But if it is something of, say, even a public-private partnership nature, should it be covered under the definition of a state? The answer is yes, it should be, because it's still a public part is still there in the private. However, if it's pure private, it is not state. But if it's government in some form, where the government has established the state board, the government funds the state board in terms of the finances. Functionally, you notice most of the electricity boards are directly under a minister and the government. Administratively, also, the appointments, as though many of these boards have now become corporation. But when I say corporation, it is like a company. It's like a government entity. The managing director, the directors are appointed by the government. So, in all of these bases, financially, functionally, and administratively, if there is an element of control by the government, whether state or center, please note these entities shall be considered as state. Right? So, either it is a creations test or it is a functional test. That test will determine if these entities are going to be called as states. Right? Now, it's irrespective of the fact that the electricity board may not be covered under strict definition of a sovereign function of the state. But please note, Article 12 has, as I told you, several components to it. Yes, the sovereign entities and the sovereign functions are definitely under Article 12. However, when the term other authority appears in Article 12, all of these entities can be covered, and they will be regulating, probably, or affecting or determining any of the rights of the citizens, and they would be held accountable for any of their public functions, public administrations, and of course, the element of good governance that brings in efficiency and effectiveness of the realization of rights. Now, the Rajasthan electricity, state electricity versus Mohanlal is an important case. However, there are two other very landmark decisions. One is called the Ajay Hasya, the most famous case in terms of determination. So, if one looks at Ajay Hasya versus Khalid Mujib, it's a case where, of course, the issue is definitely which body or organization is included under the definition of state. But it's also about the fact that once you are a state, please note, it opens up a whole gamut of judicial review of your actions. So, who can be regulated by the judiciary in terms of your public administration? I think any agency that is covered under the definition of state under Article 12 gets easily covered by what we call as the writ jurisdictions of the court, which is, the writ where you can appeal to the Supreme Court. Or rather, you can go to the Supreme Court directly under Article 32 of the Constitution and file a writ petition, or you can challenge the same under Article 226 of the Constitution as well. So, in this case, I think when you see, the case of, say, R.D. Shetty versus Airport Authority of India, this also was delivered by Justice Bhagwati. He did state how to test a state, and he laid down 6 factors. The first factor, he said, let's see whether this capital to this entity comes from the government, say the share capital, or any other funding or investment comes from the government. If for any kind of a corporation, cooperative, society, trust, board, if the share capital comes from the state funds, which is the funding of the citizens and the taxpayers' money, which is in some sense the chief financial resource or the main financial funding. See, later on you can fund it from other factors, but even the base funding, the foundation funding, the share funding, the first money, as we call it, if it is coming from the government or it is held by the government, then that entity, no wonder, should be concluded as being a state. Second, very often than not, the financial assistance of the states will be actually given to such corporations. So initially, it may not be funded by the government. It may not be the base funding, the foundation funding, but the state is continuously giving assistance. This could be, and some very interesting example of this could be a private aided college. This could be in terms of, say, giving financial assistance to an institution as terms of financial aid or state aid on a year-to-year basis. Now, if this is the case, then these private aided institutions will definitely not be covered under state. But if it's state aided institutions in any form, be it the salary or be it any other component in which they are getting some financial assistance of the state to meet their expenditure, then those corporations or entity shall also be covered as state under Article 12. Interestingly, you will notice that if a corporation enjoys some kind of a state monopoly or state is protecting their business as a monopoly business, if the state is controlling the affairs or the functionality is such that it is of a government character, nature, or importance, then in those circumstances you will notice, and please note this was pre-LPG era, if the government looks at an entity to do the sole business on behalf of the government, then in those functional characteristics, you will notice that that corporation will be held to be a state. It will have the character of government, despite the fact that the funding has not come. So this is where we call about the character, the nature of that organization will matter. Though the funding may come from somewhere else, if the nature of the matter is such that the government is protecting its monopoly status or its status of public importance, it has every character to do government functions, then it will also be considered as a state. Of course, the next character is the deep and persuasive control of the state. Deep and persuasive. See, deep means core, persuasive means continuous. Control, if it's there on the organization, then such organization shall also be considered as state. Now, please note here that it's not one may say that in most cases the government has control. Say if you're opening a restaurant, the government has control. If you're opening an institution, the government has control. If you're opening a business, the government has control. But these are just control. They're not deep and pervasive control. Pervasive control, sorry, would mean control that is of continuous character and nature, and deep would mean something that is fundamental to the management of that entity itself. Of course, a department of a government can be transferred to a corporation. This is possible in terms of, say, initially the electricity department was there, then we transferred it to corporations. For better efficiency, this was done in the electricity department. So generation companies were made different, distribution companies were made different. So these were made for better efficient management. So once a department of the government is split into corporation, doesn't lose out the character of it being a state. So that is something that we'll have to take into consideration as well. So that will continue to hold uh, uh, the corporation, the government to be state. So these tests that were put by R.D. Shetty versus the Airport Authority of India, uh, you will notice that whether Airport Authority of India. Now this is a regulator of great importance today. Airport Authority of India actually manages airports in India. Many of these airports have been given for private lease. Um, um, the Bangalore airport, the Bombay, Delhi, privatization has taken place. Many of the airports are a PPP project. Many of the airports are managed by Airport Authority of India. However, none of these would mean that though the Ministry of Civil Aviation is the nodal agency for establishing airports. Through this agency, now they create an Airport Authority of India, they manage airports through this agency. Please note, airport still is a governmental character function. And being governmental character, you will notice that it may finance it directly or indirectly. Initially, probably creation it financed. Later on, it may not do that regularly. Airport Authority of India now has started to generate its own money through tickets and so on and so forth with the usage of space of airports. However, I think mostly you will notice this is a monopoly status that is given to these to the Airport Authority of India as a regulator. Of course, it involves private players because that is where efficiency of administration comes in. So the question in RD Shetty was whether Airport Authority of India is a state. Very clearly, right? Now, because it's a kind of an independent organization, it can be independent functionally, it can be autonomous functionally. But what is its purpose? The purpose is to perform what the government ought to have performed, right? That is creation of airports. It's the central government that has the domain in the constitution for creation of airports. It's not the state government that can do so. They need a regulator to manage these efficiently. So you create a corporation style of administration, which is a company style of administration, where you bring in a little bit element of functionality. So looking at the various aspects, for example, I can just put in the deep and pervasive control of the state. Now, does Authority of India have deep and pervasive control of the state? Of course, it has, because everyone who works over there is appointed and responsible to the government, and they are performing a character which is of public importance, which is a kind of an arm's length character sometimes, because the government wants to have the airport authority a little bit far away from it because it can work efficiently and there's no government regular bureaucratic interference. It can bring in standards, it can improve services, it can improve the experience of citizens as well. However, you will notice that being the purpose, it will not lose out as being treated as state under Article 12. So the implication between Ajay Hasya and the Authority of India case or the RD Shetty versus India case is very simple. The simplest form of looking at this, look, in Ajay Hasya, I said, can someone file a writ petition against you because you're a state under Article 32 and go to the Supreme Court directly for the enforcement of your fundamental rights? In RD Shetty case, it would mean that if you're a state, you have to follow certain government norms of, say, you can't go in for a private recruitment. You have to go in for a public kind of a recruitment. You have to show transparency. You have to show accountability. You have to follow the principles of natural justice. The principles of good governance apply to you. So, which means corruption has to be, investigated by the Lokayukta and the Lopa. It also means that you have to follow the process of tendering. Right, tendering is very important because that is transparency and accountability route. You have to look at participation approach, and all these aspects of good governance, equity, efficiency, rule of law. All this then become inevitably a rule for the entities like state who are so-called local authorities. They are then made responsible to follow the rules of good governance. So I think what is important here is to try and understand that there are implications once you are declared a state. Those implications could be as simple as that the Prevention of Corruption Act applies. Of course, it does apply to any other institution, but primarily it applies to the state. It also means that once you take aid from the government, you are a state. But once aid comes in, some degree of control from the government also steeps in. There is no prohibition on seeking aid, but the implication is you are accountable under Article 12. Uh, you may be commercial or non-commercial. That doesn't actually matter, So even commercial entities, which are established by the state, they can be purely for profits. They are there. For example, you have so many public sector undertakings. The public sector undertakings' basic purpose is commercial. Say Hindustan Aeronautics Limited, ONGC Limited, Coal India Limited. All these are commercial entities. They're not like non-commercial entities, right? For example, today, if you ask me whether Airport Authority of India is a commercial entity, it is a semi-commercial entity, though it has so many public welfare functions in terms of establishing these airports, running the airports, creating a kind of a facility for the same. However, all of these implications then become very critical, because then you are looking at so many other authorities that have to be declared under Article 12, and we thereby bring in a constitutional accountability for that same purpose. Please note, government can establish companies as well. Right? Companies under the Companies Act of 2013, government can register what is known as a government company. What is a government company? It's a company in which the government state or center has more than 51% of shares. Of course, today there is so many of these companies in which the shares have been diluted, disinvested. The government may be a major shareholder. 51% and more is a major shareholder, very clearly calling it as a state. But in many cases where the government is a minor shareholder, the test of other authorities will have to be applied. So if you are as an investor, then you're not going to be considered as a state. For example, LIC, the Life Insurance Corporation of India, it is actually a state. Now that state makes an investment into Infosys. Doesn't mean Infosys is going to be treated as a state, right? So, having said all of these, Life Insurance Corporation of India and other entities which are created as a commercial wing of the government are held accountable. So that indirect accountability can be established, but the direct accountability is something that will have to be tested from time to time.